When will courts enforce the promises that people make to each other? How will they interpret what those promises mean? When will they find those promises were performed and when breached? And if breached, who owes money to whom? We'll answer those questions and more in this Contracts Review.
Output and requirement contracts are special types of contracts that often come up regarding the sale of goods where a quantity term is not specified. Every contract, including requirements and output contracts, must have mutual assent plus consideration or an alternative thereto. Mutual assent consists of an offer plus acceptance, and consideration means that the bargain was induced by what the promisor was receiving and what the promisee was receiving. We also have learned there are some exceptions, equitable exceptions in promissory estoppel or promissory restitution when consideration is not found. But the key issue in a requirement or output contract is about the offer, because the offer must objectively manifest the promisor's intent to be bound, must be understood by the promisee as inviting the conclusion to a bargain, and, this is key here, must include definite terms that a court could enforce. Usually, those definite terms are price, quantity, and subject matter of the contract. But the nature of a requirements contract is to be missing the quantity term. This is a particular type of incomplete contract. Many contracts are incomplete for a variety of reasons. In fact, some would argue that all contracts are effectively incomplete because you can't always know the future. But requirement and output contracts are incomplete in a very critical way. They're missing the quantity term. You don't know how much you will buy or sell under such a contract. Usually, courts will not enforce contracts that are missing quantity terms. It turns out there's a very good reason why these type of contracts potentially should not be enforced. They have two substantial economic problems. The value of a contract with a counterparty is that you have a binding agreement. But the nature of missing a quantity term means that the party who is benefited by changing that can renegotiate the quantity in the future. During renegotiation, there might be opportunistic behavior. One or both parties could attempt to get a higher percentage of the transaction's benefits by threatening to walk away from the deal. Since parties will be able to walk away from the deal, parties may not enter into deals in the first place, which causes a problem of underinvestment, because the contract will be hard to enforce, and so it doesn't have a lot of value. You won't take the time and effort and money and legal fees to negotiate a contract which won't turn out to be enforceable. In addition to the holdup problem, which can lead to underinvestment, there's also a problem with overinvestment where there are damages provided for a company that does not perform under a requirement and output contract. While there may be no social value in producing the good or service in the quantity that is specified, the party may be seeking money damages from failure to produce this quantity. And so the party will overinvest in the relationship that has no or minimal social value. That's one reason, theoretically, why quantity is usually a required term in all contracts, particularly with sales of goods. In fact, the Uniform Commercial Code, which governs sales of goods, specifically says that sales of goods over $500 need to be evidenced by a signed writing that includes a quantity term. So, why do we have these output and requirement contracts that don't have this quantity term? And how do we get around the holdup and overinvestment problems that can be caused by these type of contracts? Let's look a little more deeply at some examples. An output contract is quite simply where the producer agrees to sell and the buyer agrees to buy the producer's entire output. All of the output will be purchased by one buyer. A requirements contract is the flip side. The buyer agrees to purchase all of its goods from a particular supplier of one type of good. In this case, this gentleman has decided to buy all of his hot dogs from Oscar Mayer. He can't go somewhere else for hot dogs, but Oscar Mayer will sell him only as many hot dogs as he can eat in this contest. An example of an output contract can be found in the case of Feld doing business as Crushed Toast Company versus Henry S. Levy & Sons. Here, the defendant agreed to sell and the plaintiff agreed to purchase all breadcrumbs produced by this factory. It turned out that it wasn't very economical to produce breadcrumbs. They were making them at a loss, so they simply stopped making breadcrumbs and output went to zero. The plaintiff sued, saying, "I'm owed breadcrumbs at a stated price." And the defendant replied, "You get my entire output and my output is zero." Was this a breach? On the flip side, let's look at a requirements contract from Orange and Rockland Utilities Inc. versus Emerita Hess Corporation. Here, the defendant agreed to sell and plaintiff agreed to buy all of its fuel oil needs at a stated price of $2.14 a barrel for a period of time. The plaintiff estimated needing less than 1.75 million barrels, but when oil prices went through the roof, through $4 a barrel, plaintiff increased her purchase order by 63% because it realized it could resell this oil on the secondary market. Was this a breach by the buyer? Again, this is an economics issue. This is evidence of opportunistic behavior, where a party has entered into an incomplete contract and now is attempting to extract some of the wealth surplus from the transaction. To put it in more generic terms, if a contract price exceeds the market price, the buyer might demand 0 units, claiming they have no requirements. Because they don't want to pay the higher contract price, they're just going to go to the market. If you have a contract to purchase all of your pencils from Office Depot, and the contract is for 2 cents a pencil, and for whatever reason the price of pencils on the world market has dropped to $1.50 a pencil, you don't want to spend $2. You'd rather pay $1.50. On the flip side, if the contract price is less than the market price, the buyer might demand additional units. You have a great deal. You can buy as many pencils as you need for $2, and now pencils are worth $3 on the open market. So you'd like to purchase as many pencils as you can for 2 cents and resell them for 3 cents. This is the type of economic problems that arise when we have contracts without a quantity term. And again, quantity is usually a required term so that contracts can be sufficiently definite. Without the contract having a quantity term, it's susceptible to this opportunistic behavior because it's incomplete. However, the Uniform Commercial Code recognizes that these type of contracts are commercially necessary and provides a framework to fill in these missing terms. UCC Section 2-306(1) provides a term which measures the quantity by the output of the seller or the requirements of the buyer means such actual output or requirements as may occur in good faith, except that no quantity unreasonably disproportionate to any stated estimate or in the absence of a stated estimate to any normal or otherwise comparable prior output or requirements may be tendered or demanded. So the UCC provides in Section 2-306(1) both a limitation on the ability to demand additional units and a good faith requirement, which is found in all contracts. UCC 2-306(1) limits exploitation by the buyer by stipulating that the requirement demanded or supplied cannot be unreasonably disproportionate to either a stated estimate or a comparable requirement demand. Again, the UCC does bring up good faith. Good faith is an implied term in all contracts, and it applies here as well. And so one issue that can come up is whether ceasing production in the case of the crushed bread company was done in good faith, or whether the purchasing of additional oil, or in our case, additional pencils, was done in good faith. Generally, purchasing to make a profit off of resale is not in good faith. And shutting down your factory because it's no longer profitable for you to do so is also not in good faith of the contract. So to summarize, quantity terms are usually required in contract formation, but sometimes commercial agreements are necessary where they don't state a quantity term and instead talk about the amount that is required or the amount that can be produced. The UCC provides a framework for preventing some of the economic abuses, such as the holdout problem that can result in underinvestment in these contracts. And good faith is a backstop to all contracts, which also applies here and limits the amount that the buyer can order or that the seller can produce in good faith.
Thanks for tuning in to today's video on contract review. I hope it was helpful to you. If it was, please check out my channel for other videos. Good luck with your studies.